Hi all. This video examines Aboriginal persons and the criminal justice system in Canada, particularly the role of rehabilitation. In this video, I will first discuss the overrepresentation of Aboriginal persons in Canada's criminal justice system. Specifically, we will look at both the federal and provincial levels. Next, we will look at a variety of factors, both past and present, that have and continue to result in the overrepresentation of Aboriginal persons in the justice system. Third, our attention will turn to approaches taken by Parliament and the Supreme Court to mitigate overrepresentation. I'm going to place particular emphasis on initiatives taken by both Parliament and the judicial response. Finally, we will evaluate the effectiveness of these efforts on reducing overrepresentation and forecast what the future holds in this area. So this map that I put together illustrates the proportion of Aboriginal persons living in each province and territory. It also shows the composition of incarcerated Aboriginal offenders as a part of the entire provincial or territory population. These purple numbers denote the percentage of Aboriginals as part of the population living in each area, while the red identifies the percentage of Aboriginal offenders that are incarcerated. In almost all of these cases, at the provincial and territorial levels, Aboriginal offenders are grossly overrepresented in prisons compared to their population composition. For example, in Saskatchewan, despite being only 15% of the population, Aboriginals represent 76% of the incarcerated individuals. As well, we can see there's a significant concentration in this proportionality element in the central west provinces, as well as in the territories. In fact, mass incarceration is 3 times higher in the territories than any other part of Canada. Historically, this is where Aboriginal persons have been forced to relocate to. At the federal level, Aboriginal persons make up 4% of Canada's population, yet they are 24% of the inmates. In fact, they are more disproportionately represented than any other group, and in recent years, the length of their sentences have been increasing. Furthermore, the rate of incarceration among female Aboriginal persons has increased by nearly 20% since 2004, and 40% of incarcerated women are of Aboriginal descent. A final rattling illustration of this disproportionality is evident in the recent increase of incarceration. As the graph shows, not only has overall incarceration increased, but the proportion of Aboriginal women and youth incarcerated has increased as well. In fact, Indigenous incarceration has more than doubled in the last 10 years, whereas non-Indigenous incarceration has stayed relatively stagnant. So what accounts for this disproportionality? In large part, Canadians have recognized the impact of historic events coupled with social and political forces that have negatively impacted Aboriginal persons in Canada. Namely, the impact of colonialism and legislation has had the largest impact. By colonialism, I'm referring to the dominance asserted by Europeans in the early days, and in consequence, the subjugation of Aboriginal persons. As such, Aboriginal people have and continue to face systemic and direct discrimination as a result of a variety of events. One of these events is residential schools, which are essentially a boarding school for Aboriginal persons. They were funded by the Canadian government and operated by the Christian Church. As such, these schools were factually an attempt to assimilate Aboriginal persons to European traditions. Within these schools, students experienced many injustices such as forced religious indoctrination, anti-Aboriginal curriculum, abuse, confinement, and even health experimentation. In fact, students were taken and forced to attend these schools, they were punished for using their native language or culture, and many Aboriginal persons characterized them as prisons. Similarly, the 60 Scoop was the taking of children and placing them into adoptive families, predominantly white middle-class families. Not only were they forcibly removed, but it was an attempt to assimilate them to separate them from their families, communities, language, and culture. These are just 2 examples of the many ways that the government's use of Euro-Canadian doctrine was and is an attempt to assimilate the lives of Aboriginal persons by use of forced relocation and cultural interference. The disproportionality can also be attributed to the lack of resources and opportunity available for Aboriginal persons. There were and continue to be minimal Aboriginal-specific institutions, that is, organizations or resources that specialize in the care and support of Aboriginal groups. In addition, Aboriginal people continue to remain vastly unemployed due to a lack of education and skill training. Furthermore, the stereotypes associated with the group affect this. 95% of Aboriginal people also do not have access to adequate legal assistance due to overwhelmed resources in the justice system or lack of access. So in sum, the disproportionality of incarcerated Aboriginal offenders is largely due to the denial of human rights, alcohol and substance abuse, neglect, violence, poor health care, poverty, and the loss of culture. And the recent rise of incarceration is partly attributed to the re-victimization of survivors in failed attempts at rectifying the historical inequalities. So in response to all this, Parliament in 1996 recognized these problems and amended Section 718.2e of the Criminal Code of Canada. The section reads that a court that imposes a sentence shall also take into consideration all available sanctions other than imprisonment, with particular attention to the circumstances of Aboriginal offenders. This means that when sentencing an offender, a judge must consider reasonable options other than incarceration, but especially in the case of Aboriginal offenders. This recognizes the consideration towards Aboriginal persons, however, it did not prove substantive in empirical terms. In the 1999 Gladue ruling, the Supreme Court ruled that this criminal code provision must emphasize the role of judges in preventing overrepresentation of Aboriginal persons. Judges must consider the factors that have brought a particular Aboriginal person before the court. This includes both discriminatory practices and background factors such as cultural interference and forced relocation. The 2012 Ipili ruling further stressed a restorative justice approach in attempting to rehabilitate rather than punish through acknowledging these hardships. In the years since Gladue, the incarceration for Aboriginal offenders actually increased due to a lack of consideration towards the Gladue principles. The court explicitly indicated that a direct causal relationship need not be present. Rather, the hardship faced is evident in the past and continued treatment of Aboriginal persons. So there are two main ways that sentencing reform has occurred beyond this. The first is the use of Gladue reports. These are a form of pre-sentence reports used in bail or sentencing hearings that outline the systemic and background factors. Thus, these reports clearly outline the background factors that brought the offender before the court. However, despite the increased use of Gladue reports over the years, they are not always used effectively. This is due to a lack of judicial training and an overwhelmed system. So as we see in the image, the balance between them does not promote healing right. Rather, the Gladue court is a second attempt. These are specialized courts that address the overrepresentation of Aboriginal offenders. These courts use a different approach than the historical approach, the specialized focus of personnel and resources. For example, judges, counsel, and other members of the court are more knowledgeable and sensitive to Aboriginal communities and justice initiatives. Furthermore, the centralization of resources allows for easy access and clear explanations. Thus, there's a particular understanding and expertise of the range of programs and services. This difference is best exhibited through the examination of sentencing guidelines. In Canada, judges will consider how a sentence deters and denounces a particular offense, as well as how it helps rehabilitate the offender and reduce recidivism. Thus, this refers to the prevention of recommitting a crime. The Gladue courts, however, place less attention on the former two, while emphasizing rehabilitation and reducing recidivism. Thus, this system is more communicative and resource-driven to attenuate restorative justice principle. So when we look at the success of these attempts, we see that various reforms have been somewhat successful. As previously explained, each reform built on the previous in rectifying mistakes and trying to improve the system. There's been a paradigm shift towards restorative justice. This involves the implementation and use of community-based programs and sentencing circles to restore balance between the offender, victim, and community. There has also been a significant increase in emphasis on prevention and rehabilitation. Courts are able to and do deliver more culturally appropriate sentences that consider the background of offenders. These sentences are much more likely to result in rehabilitation while emphasizing Aboriginal traditions such as greater interaction with community members. So when we look at the benefits and shortcomings, the empirical results of Gladue courts depict both of these. First, there is a large decrease of recidivism of up to 84%, thus offenders who elect to use Gladue courts are much less likely to commit another criminal offense. In addition, aggregated data on sentencing illustrates a less punitive and more community-based rehabilitation process. As such, incarceration levels have decreased while the use of community programs have increased. 2014 statistics show that 1 in 15 Aboriginal offenders use a Gladue court, and 1 in 7 offenders use a Gladue report in their leading procedure. However, despite all of this, incarceration rates remain high. Only 12 of these specialized Gladue courts exist in Canada, and they remain concentrated in dense urban areas. Aboriginal persons continue to have a lack of resources such as money and legal aid. This means they are further disadvantaged during their legal proceedings. Another shortcoming of these reforms is that they have not rectified the problem of systematic discrimination. Aboriginal persons continue to face different and unfair treatment because of who they are within many institutions. So where does this lead us? We must continue to recognize the hardships faced by Aboriginal people. It is a multifaceted concern that needs to be targeted for more than Parliament or the courts. The poverty, abuse, racism, health crisis, and loss of culture for Aboriginal have greatly impacted their lives. Furthermore, policies and practice can be implemented to eliminate the occurrence of discrimination, such as limiting the use of mandatory minimum sentences, as well as improving access to resources and institutions for Aboriginals. These include more legal aid and specialized resources such as Gladue courts and further training for all legal personnel, as well as an increase in culture-relevant prison programs, Aboriginal healing lodges, and the reintegration of Aboriginal offenders can help rectify this problem. In sum, while progress has been made, Aboriginal offenders continue to be adversely discriminated against, and we must dedicate more resources as well as consider other methods and approaches to improve the justice system. This final slide includes references and further resources if you want to learn more about the topic and what can be done to help Aboriginal persons in Canada. Thank you for taking the time to view this video, and hopefully you've learned how we can continue to help our Aboriginal population in Canada.